Today's webinar will be joined by Sam Hahn. So he is one of LawPath's most senior lawyers. He has extensive experience in a range of legal areas in commercial and business law, including but not limited to commercial contracts, employment law, establishing new businesses, purchasing and sale of businesses, and advising on compliance with consumer rights, competition law, and privacy law. If anyone wants to see more information on Sam and see our other lawyers on the Meet the Lawyers page on our website. You can see their lovely faces there. For example, Sam has a 5 out of 5 star rating out of over 100 reviews. But Sam's going to cover today legal planning, reflecting on your business structure, reviewing business contracts, and planning ahead. Finally, we'll speak to how LawPath can help, as always, and then we'll conclude with a Q&A session. So if at any point during this webinar you're reading the slide or you're hearing something and you have a question on it, please submit it in the Q&A chat box. Now, most people in this webinar do not have a legal background, so you're not expected to know the basics, let alone the nuances of commercial law. And we're also a slightly smaller group. We've had a few webinars with 50 to 100 people, and that sometimes actually makes it quite difficult to get to everyone's questions at the end. So I'll actually put it out there. If you do have a question related to this topic or maybe something else, if we have time, Sam can also answer that, as long as it's always related to business and commercial law. So please submit it in the Q&A. We'd love to answer that for you at the end of the web. But if you obviously have multiple questions, you can actually book in with Sam or any of our other lawyers. We do provide unlimited consultations through our legal advice plan. So those of you who are new to LawPath, we're an Australian-based online digital legal platform. We are fortunate to be Australia's leading online legal platform for small to medium businesses. And while we do reside in Sydney, we're working with many successful businesses across the whole country. To date, we've helped over 500,000 startups in multiple different ways over the last 10 years. But fundamentally, we're here to save you money. Our single mission is, we do not believe startups and small businesses should be paying extortionate fees for their legal and accounting services. So stick around also to the end of this webinar. We'll actually be offering a 7-day free trial of that legal advice plan. So if you would like to claim it, it does start today for those here. Another reason, actually, if you want to speak to anyone about that after this webinar, just type yes in the general chat box, and we can even actually demonstrate the platform to you as well. However, if you would like to check us out, more information about us in your own time, I'll include some links in the general chat box. These include our reviews, some success stories, the link to see our internal lawyers, and testimonials submitted by our clients, as well as our LinkedIn page. Right, that's enough from me. We'll jump. We are running behind, so we'll jump right into it. I'll hand things over to Sam.
Great. Thank you, Connor, and welcome everybody to our webinar. So today we'll be discussing various legal considerations you have to put your mind to when scaling your business. It's a really broad topic, and so we've just handpicked a few subjects to cover today. The first one being the business structure. So what sort of structure your business has, whether that needs to be revised. And then the second part being contracts, the contracts that you have with your suppliers and customers, and whether that needs to be reviewed, updated. And then thirdly is about staffing. So increasing your headcount, which you'll need, will probably need when you're scaling your business. Just some basics around employment law and hiring contractors for that purpose. There are other considerations as well, intellectual property, trademarking your business name, logo branding, and a whole host of other things. But those three are probably the three topics that I've just mentioned: structures, contracts, and employment. They're probably the three sort of foundational issues that we need to cover when scaling the business. Now, scaling can mean different things to different types of businesses. So you might be a high growth startup looking to investment, or maybe you've already got seed funding and you're looking to raise more. You might be an established, more traditional type of business, and not a high growth startup. You might be running a retail shop, could be a restaurant, could be a mechanics workshop or what have you. and you want to just expand your business, establish another branch, or just upscale your existing operations. And so scaling can mean different things to different people. But one of the things to consider when scaling your business, whatever type of scaling you might be talking about, is having a look at your business structure and whether it's still fit for purpose. And many times, especially for more traditional businesses that are not sort of high growth startups, the most common kind of business structure is a sole trader. So, if you're a carpenter or a plumber, you might just take out an ABN in your own name and start doing work. That can even include people like bookkeepers and so on. As opposed to, let's say, forming a company, which might be, driven by wanting to raise capital or wanting to mitigate legal risk. It's a slightly more complex structure, still relatively straightforward. But whether you're a sole trader or a company, it's probably a good idea to have a think about whether that's still fit for purpose before you start scaling up. So if you're a sole trader, got to think about whether it's time to form a company. And if you are already a company, perhaps it's time to start thinking about whether to establish a more sophisticated corporate structure. And along with the legal considerations, you've also got tax considerations as well, because whatever structure you adopt will influence how you manage tax compliance and how much tax you might have to pay, whether it's income tax, whether it's capital gains tax, stamp duty, and so on and so forth. And so whenever you're thinking about business structure, don't just think legal, also talk to your accountant. If you don't have an accountant already, we at LawPath have services for tax compliance and advice. So please reach out to our team and we'll be able to explain to you what those packages include and how much they cost and how they can help you. So the two simplest business structures, sole trader and a company, or namely a proprietary limited company. So when you see the words Pty Ltd after a company name, that means it's a proprietary limited company. It means it's a private company, not a public company that obtains funds from the public. And it is a limited liability company. So limited means that the shareholders' liability is limited to however much they need to pay for their shares. So as a sole trader, the basic pros for that is it's simple and it's cheap, right? You register an ABN and off you go. Perhaps you do register for GST if your turnover is more than $75,000. So it's simple, it's cheap to run. The cons of a sole trader structure is you bear all of the legal risks that come with your business. So if anything goes wrong with your business, if you breach a contract, if you're negligent or what have you, you are personally liable for that. And so you expose yourself to the risk of, say, bankruptcy, and in some extreme cases, maybe even imprisonment. And it can be difficult to plan for succession. What happens if you die or you become incapacitated? Who takes over the business then? If you're by yourself, perhaps the business simply winds up with you. But if you have employees, if you have other people working in the business and you have a large number of clientele, you should probably think about how you're going to deal with that if something happens to you. And then the third disadvantage of a sole trader structure is that you have limited ability to raise capital. It's basically limited to taking out loans. Unlikely that you'll get donations. So if you need more money to expand your business, you'll probably have to take out a loan. And so as a sole trader, it's simple, straightforward, but it gives you very limited options to expand your business and you bear all the personal risk. If you form a proprietary limited company, the advantages of that is that you can raise capital by issuing equity. So in other words, issuing shares in the company, as opposed to a loan, which becomes debt that you have to repay. If somebody invests money into your company and they're issued shares, it's not a loan. Then if the company doesn't do so well, and they don't get paid as much dividends as they would like, then that's just bad luck. It's just one of those gambles that investors take when investing in a business. So that's an alternative option for raising capital if you're a company. Legal risk is generally borne by the company itself because the company is a legal person in its own right. It contracts in its own right, bears liability in its own right. And although directors can have some liability for specific things, such as failure to comply with GST law, failure to comply with superannuation laws, some types of workplace and health safety breaches, and so on. Directors and shareholders are generally not liable. And if you're only a shareholder and not a director, your liability is limited to whatever amount of money you ought to pay for the shares. So let's say you're issued with 100 shares worth $1 each. So that's $100 in total. If you've already paid that to the company, then your liability is no more. If you haven't paid it to the company and something happens with the company, then and it gets liquidated or wound up, all your liability is just basically limited to $100. And it's also easier to plan for succession because a company that loses a director could appoint new directors onto the board. If a shareholder becomes incapacitated or dies, their shares go to their successor, under a will. Cons of a proprietary limited company is it is more costly to set up and operate. Okay, so the ASIC fees currently for registering a proprietary limited company is $576. If you get an accountant or a lawyer involved, there'll be some professional fees on top of that. Companies generally file tax returns through a tax agent or an accountant, so there'll be professional fees for that as well. You can do it by yourself, but it's not really recommended. And then there's the regulatory compliance burden. So ASIC will issue a review statement every year, and you need to pay fees on that. You need to report to ASIC if there are any changes to the company and so on and so forth. So there is more of a regulatory burden. It is more costly to set up and operate, although it probably wouldn't break the bank. But there are some significant advantages in terms of capital raising, risk mitigation, successful plan. Now, if you are already a company or you want to set up a company, then the other thing to think about is how simple or complex that structure should be. Now, a fairly common next step, if you've already got a company or you want to set up a new company to run your business, is having two companies instead of one. Now, why do you want that, maybe? So one of those companies would be what's called a holding company. So a holding company owns all of the intellectual property, capital assets, such as equipment and plant, and may even own most of the cash at bank. There will be a second company incorporated, which is the operating company. And it's called that because it operates the business, right? It trades with the customers and suppliers. If the business needs premises, it leases the premises, it hires and manages staff. The holding company is called a holding company because it holds the assets. Operating company is called the operating company because it operates the business. And so most of the value in the business sits with the holding company. And whereas the legal risks are taken on by the operating company that actually does the trading, deals with the customers, suppliers, staff, and so on. So the operating company takes on the legal risk. Most of the assets are held in the holding company, which is a separate legal person. And so if somebody sues the operating company, something goes wrong, most of the company assets would be protected because it's held by another entity. And there's a flow of monies, there's a flow of rights, such as right to use IP, right to lease equipment, and so on and so forth. You as the business, I guess the ultimate business owner, would own shares in the holding company, and the holding company in turn would own shares in the operating company. So if you've got like a food chain, you sit at the top, underneath you sits the holding company, underneath the holding company sits the operating company. So that's a dual company structure, and it's designed for legal risk mitigation to try and protect the business assets as much as possible. Now, there is another type of structure called trusts, where you might set up what's called a trust. It is a little bit more complicated topic, and so we haven't included slides on that here. We'll probably blow out the webinar time by a good amount if we went down the rabbit hole of trusts. But what trusts help to do is it helps to protect your personal assets. So you might set up what's called a family discretionary trust that allows benefits to be paid out to your family members at the trustee's discretion. So the trustee is the person who manages the trust funds. And the trust may own shares in your company, whether it's just one company or whether it's a dual company structure. And so that helps to optimize the tax outcome because you can distribute benefits to beneficiaries of the trust in a way that minimizes the overall amount of tax that's paid. But it also helps to protect your business, your personal assets, because you don't hold the assets for yourself. You hold those assets for the benefit of the beneficiaries, for other people. But anyways, reach out and speak to us if you are thinking about setting up a family trust or it sounds interesting and you want more advice, and we can help you with that. Now, raising capital. Now, we discussed this particular topic specifically because many of our clients are startup companies and sort of aiming to be high growth startups. And capital raising is a very important issue because you're not going to have sufficient capital to keep running the business and make a profit, at least not right now. So when you're dependent on external capital, how do you raise that capital? So, I mean, you could go take out a loan, but that loan has to be repaid. If you're a sole trader, that's pretty much the only option. If you're a company, though, you can raise capital. You can receive funds in exchange for equity, and typically that equity will take the form of shares. So every company is constituted by shares. A company needs to have at least one share issued to a shareholder. Basically what would happen is an investor would come along, attracted by your business proposition, thinks it's a good idea, happy to pay the company money in exchange for a slice of the pie. So say investor pays the company $10,000 and you promise to give them 10% of the shares. And so let's say if the company has 100 shares issued, you promise to give 10 of those shares to that investor. It's not a loan, but it's a capital injection. And if the company performs well, the investor can sell their shares at an increased value. So therefore they make a profit. If the company performs badly, well, it's unfortunate, it's bad luck for them. If the business structure, if the corporate structure you've adopted is a dual company structure, then typically the investor will invest money into the holding company because that's where all the assets and the value is contained in, and they will be issued shares in the holding company. It's not always the case, but it's typically the case. The legal documents that you would need. So initially, the parties would negotiate what's called a term sheet, which is it's a very basic general outline of what the investment will be about. There'll be some terms in there about confidentiality and IP and so on. There might also be provisions saying that the parties will formalize the agreement by entering into a share subscription agreement, which is a formal agreement saying that the investor will invest a certain sum of money at a certain point in time and be issued some specified shares in return. And there might be a whole bunch of other clauses related to that. And then there will be a different legal document called a shareholders agreement. So a shareholders agreement is an agreement between the company and all of the shareholders, which governs the rights and obligations of the shareholders. So what the shareholders must do when they want to dispose of the shares, if they want to sell off the shares, how the company's decisions are made, what kind of decisions require, at least a simple majority vote, what requires a special majority vote, 75% or something to that effect. And the various duties of shareholders, if those shareholders also appoint directors to the board, and the composition and how the board is governed as well. So the shareholders agreement is like a big rule book that all the shareholders sign up to, including and the company signs up to as well, governing the rights and obligations of the shareholders. So under this sort of particular example of capital raising, so you'd have those three legal documents. There may be other legal documents required. So let's say the investor wants to come on board, but doesn't want to be just a passive investor. They want to actually be involved in the business, perhaps be appointed as a director. That might involve them having to sign up to directors agreement. So we've done a very quick overview of different business structures, a dual company structure, and the processes as well as legal documents that are required for capital raising. If you need more advice or you have a question, feel free to ask that in the Q&A. Otherwise, reach out to us and we can either provide you advice via a consultation through one of our plans, or we'll provide a quote for that advice. Now, other than structuring, the next thing to really think about is your business contracts. So how you engage customers and suppliers. And the first thing really is to see whether you actually have contracts. A lot of businesses don't operate under a contract, under written contracts. Look, a contract does not necessarily have to be in writing. So you can have verbal contracts, contracts that are construed by actions of the parties and so on. But all of that is very uncertain. It is hard when you're relying on verbal agreements, when you're relying on agreements by conduct. It's very hard to find out what has actually been agreed, what the terms are. And so having written contracts is, it's extremely highly recommended because it sets out clearly what the rights, the obligations of the parties are, what that agreement is actually about. And so if you don't have written contracts, draw them up, contact a lawyer or contact us to draw up the contracts. We have a massive number of business contracts available on our platform that you can have a look at and work on. But generally speaking, when you're reviewing contracts, some of the things to really look out for are other parties clearly specified, right? So if something goes wrong with the contract and you need to sue somebody, or the other party wants to sue you, you've got to know who it is that you're actually dealing with legally. Who are the legal entities or persons that are involved in the contract? So the parties need to be clearly specified. So the legal names, and if it's a business, the identifier of that business, whether it's an ABN or an ACN, should be clearly specified in that contract. If it's a company, preferably you would use the ACN. If you're a sole trader partnership or a trust, then it would be the ABN that you need to specify. And then the other obvious thing is, are the rights and obligations for each party clearly stated? So follow the good writing sort of rules that we were taught at the school. So the who, what, when, how, and I know that the fifth one is why. But for the purposes of contracting, the main thing is who, right? So who has the right to do or not do something, and what is it that they have to do or not do, and when they have to do it. Now, sometimes the contract might go into why, but that's a bit of an optional thing. And obligations, who must do or must not do something, what and by when, right? So Alice must transfer 100 shares in Alice Proprietary Limited to Bob by the 30th of May 2024. And that there might be a separate clause saying how she actually has to do that, right? Execute a share transfer form, register the transfer of shares with ASIC, et cetera, right? So think of these elements in mind, and when you're reading through a contract, just see that all the elements are there. The contract itself, like how long does the contract last? Is it ongoing until it's terminated? Is it fixed term? If it is fixed, is there a way to renew it? Is there a process? Is there some qualifying conditions for that renewal? Typically, renewal clauses would say something like the party who's wishing to renew the contract, they haven't breached it, or if they have breached it, then the breach is remedied, et cetera, et cetera. And is the renewed contract under the same terms and conditions as the current one? Sometimes the contract might say that the renewal is subject to the parties signing into the then current version of the agreement, as opposed to the existing terms and conditions. Have a look at the term, the duration of the contract, whether it's fixed or whether it's ongoing, whether there's an option to renew if it's a fixed contract, and also what laws apply and what courts have jurisdictions to settle disputes. This is really important, especially when you're dealing with international parties. Preferably, if you're an Australian business, you would want Australian law. So if you're based in, let's say, New South Wales, you would want New South Wales law to apply because it's most convenient for you. And the courts of New South Wales would have exclusive jurisdictions to settle disputes. But different. You might want to specify something different depending on the circumstances. When you're dealing with international parties, it can be difficult to enforce your rights under contract through the courts, and that's because there isn't a widely accepted treaty between countries recognizing each other's court judgments. However, there is a treaty called the New York Convention, which provides for courts in a country who has ratified the convention to recognize arbitral awards that are made in a different country. So arbitral awards are like court judgments, but they're made by a private arbitrator. So it's kind of like a private court that the parties arrange for themselves. And so there'll be an arbitrator who would typically be a lawyer or some expert in that subject matter, who would gather evidence from both sides and then make a decision on which party is right in relation to a dispute, and then create an award, saying, party A has to pay party B compensation of $100,000, what have you. And then what you would do if you have gone through arbitration, you've got an arbitral award, you would take that arbitral award to the party who is in that other country, and if that country is a signatory to the New York Convention, they should, subject to some domestic processes, but they should basically automatically recognize that arbitral award and enforce it. So if you've got a contract that you use with international parties, it's a good idea to check whether it has a clause allowing international commercial or maybe mandating international commercial arbitration, because that could make enforcement easier for you. Now, in Australia, we have, despite, regardless of what the law governs that contract, if any person deals with a party here in Australia, there are some laws that apply, irregardless of where that overseas party might be based. So unfair contract terms and consumer guarantees are two examples of that, and are particularly relevant for businesses. Unfair contract terms apply to business to consumer contracts, as well as business to business contracts where one party is a small business. And the Australian consumer law has a very loose definition of what a small business is. Basically, annual turnover less than $10 million and having less than 100 employees. And if the contract is what's called a standard form contract. Now, don't let the words fool you. The unfair contracts regime have been revised fairly recently in November 2023. The words standard form contract used to mean that it's basically just a pro forma contract, and that it can't be negotiated. But now the definition has expanded. So even if it has been negotiated, if it's been entered into in a similar sort of form with other contracting parties, that could still be a standard form contract. So if a party is a small business and the contract is a standard form contract, then the unfair contract terms regime apply. Now, a provision in a contract is unfair if it significantly imbalances the party's rights and obligations. It is not reasonably necessary to protect the interests of the party seeking to benefit from it, and it would cause detriment to a party if the other party was to rely on it. There are numerous set examples of what unfair contract terms are. The case of ACCC and Servcorp, which is a relatively recent case, there was a long list of contract terms that were deemed unfair. Some examples were the right to unilaterally increase the price without any notice. There was also another contract term which would provide for auto renewal of the contract. So just for context, Servcorp is and still is currently in the business of leasing out office spaces. So they're like managed office spaces. They also provide virtual assistant, virtual reception type service. And so their contracts with clients allowed them to unilaterally increase their prices without giving the clients any notice. The contract will be auto-renewed, and Servcorp wouldn't have to serve a notice saying that, hey, your contract is about to renew. There was limited opportunity, I think that from memory, it was something like 30 days to terminate the contract prior to the auto-renewal kicking in. So, it was quite easy for a customer to just be caught unawares and be locked into a new fixed term contract at an increased price that they weren't previously aware of. and then they will be locked into the contract without even being aware that they'll be locked into it. So there are some of the examples of what could constitute an unfair contract term. So when you're drafting contracts or reviewing your existing contract, just think about like whether it's actually balanced between the parties. It doesn't mean that you can't protect your own interests. You can, but it can't be too one-sided. All right. So for instance, it is possible to have a unilateral variation clause, but it would be subject to the party who is varying the contract giving notice to the other party what the variations are, and then giving the other party the option to terminate the contract if they're not satisfied with the variations, for example. So that's a way in which unilateral variation clause could be made more fair. But if you just allow yourself to, vary the contract without notice, without sort of any kind of consultation, with no right for the other party to terminate, it's probably going to be unfair. Unfair contract terms, there used to not be penalties attached, but now there are. I think the max penalty for a corporation is the greater of $50 million, or 3 times the amount of benefit that the company gained from relying on the unfair contract term. And there is a third limit, which I can't remember. I think it's based on turnover. So yeah, the penalties can be pretty steep. So it's a good idea to just review your contracts and just make sure that they're more balanced. Consumer guarantees. Okay, so some businesses mistake consumer guarantees into thinking that they only apply to sort of personal consumers. They can also apply to business supply of goods and services as well, if the cost doesn't exceed $100,000. So the mandatory consumer guarantees are that services will be rendered with due care and skill, and goods that are of acceptable quality and purpose. So the remedies, if it's a minor failure, so if the failure is something that can be fixed within a reasonable time, then the supplier can use their discretion to resupply that service or goods, or to repair the goods if it's capable of being repaired. Now, if it can't be fixed, can't be resupplied within a reasonable time, then at the customer's discretion, they can choose to get a refund. They could also sue for compensation for sort of follow-on damages as well. There are some limited exceptions, professional engineering, architectural services. Now, the reason why we mentioned consumer guarantees is because a lot of service contracts, product and supply contracts, they contain limitation of liability clauses. Just bear in mind that the limitations of liability might not apply if if the supply is deemed to be a supply to a consumer under the Australian consumer law. And so when drafting limitation of liability clauses, it needs to be framed so that it's to the maximum extent permitted by law, and that you're not intending to modify or exclude consumer guarantees if consumer guarantees under the Australian consumer law apply. If you don't frame limitations of liability along those lines, the courts could just strike out the limitation of liability clause altogether. And also, yeah, the other thing, warranties. So look, consumer guarantees are not influenced by any voluntary warranty you give. Any warranty you give is something that sits on top of the consumer guarantees. So don't make the mistake of thinking that if you've got some more restrictive terms for your warranty, that it somehow overrides the consumer guarantee, because it does not. So yeah, review your contracts. If you've got warranty terms, have the warranty terms reviewed as well. And we can advise you and flag any issues that might get you hooked by the unfair contracts regime or under the Australian Consumer Guarantee laws. So we've covered structures, contracts, and third and last is staffing. So when you're upscaling your business, you're probably going to need more staff. 2 ways you can address it. One is by hiring more employees, and the other is by hiring contractors. Do not confuse the two, because they're very different. So hiring employees. So all employees in Australia all employment relationships are governed by the Fair Work Act, which is a Commonwealth law. They're also governed by workers' compensation laws in each state and territory, as well as payroll tax laws in each state and territory as well. So employees, there are 3 different types. You've got full-time, part-time, and casual. Full-time workers are basically, they work 38 hours per week. The hours are usually fixed, although depending on the award, the hours may vary as well. And they're also entitled to leave under the NES, the National Employment Standards, or the award. And they are entitled to notice when they're being terminated. And they're also entitled to redundancy pay if you're not a small business. Part-time employees are basically the same as full-time, but except they work less than 38 hours per week. Now, some awards require the employer and the employee to fix the start and end times and the days of work on or before the commencement of employment, whereas other awards allow for that to be changed depending on business circumstances. So check what award applies and how you can vary hours if you do need to vary those hours. If you want to engage somebody very flexibly, so you don't want to commit to a set number of hours, then you would engage them as casual. So variable hours, they're not entitled to leave, they're not entitled to redundancy pay, unless if they work regular systematic hours. So they're basically working like a fixed hours part-time or full-time employee, but their contract just is casual. So in that case, they may be entitled to some of the entitlements that the full-time, part-time employees have. But generally speaking, if the hours are completely variable, then no leave entitlements, no redundancy pay. If a casual employee has been with you for at least 12 months, and in the last 6 months, they have worked regular systematic hours, then they may be entitled to conversion to permanent employment. So permanent employment means full-time or part-time employment. If you're a small business, the employee can request conversion, and you would have to respond to that request in writing. If you are not a small business, so in other words, you have 15 or more employees, then you have to proactively offer or decline to offer casual conversion. So once the casual employee's 12 months is up, you need to look at their working hours. If the working hours for the last 6 months has been systematic and regular, and you're capable of continuing to provide those systematic regular hours, then you would be obliged to offer conversion to permanent full-time or part-time, depending on the number of hours. When you draw up the employment contract, always check what modern award applies, if any. Also check the pay rates as well. I've given you links to the Find My Award tool, as well as the PACT pay and entitlements calculator tool on the Fair Work Ombudsman website. Very useful resources, and always have written contracts of employment so that the rights and obligations of you as the employer and them as the employee are set out clearly. Hiring contractors. All right, so when you're hiring contractors, it's different from hiring employees in the sense that you're not, you're basically hiring another business to provide you with a service. It is not governed under the Fair Work Act. And the superannuation may not be payable depending on the terms of the contractor agreement. Workers' compensation, depending on the state and territory rules, you sometimes would have to cover them under your workers' comp, but it does depend. So if you have any doubts, either contact us or contact your state and territory workers' compensation regulator, and just find out whether a particular contractor should be covered under your workers' comp. So as I mentioned before, they're not employees. You're basically hiring another business to provide services to you. What that basically means is that the focus is on the output that they provide to you, rather than the way in which they perform their work, like in terms of hours and days and so on. So contractors are responsible for delivering the services that you specify, but are generally expected to have freedom to choose how they perform their work. They're generally also expected by the court to have the freedom to contract with other parties, even competitors to you. You can, to some extent, limit that, but if you limit it too much, then the courts may be inclined to think of the arrangement as being employer and employee rather than independent contractor. The other thing to think about is, would you allow the contractor to delegate the work to their own employees or subcontractors? And also, how is the contractor being paid? Are they being paid for the outcome of what they do or for the time that they spend working. So are they being paid like an hourly rate? And that influences whether superannuation is payable. So if the contractor is a sole trader, they're paid for time worked and they have no right to delegate the work, then you must pay them superannuation. There are other types of contractors where even if those three criteria are not met, you may still have to pay super. So contractors who work as actors, as musicians, and so on, there are specific carve-outs under the superannuation legislation saying that they have to be paid super. So just be wary of that. If you've got any doubts, consult an employment lawyer or consult your accountant and get them to check the rules. Right. So, oh yeah, and one last thing. So this relates to, again, to startup companies mostly. But if you want to incentivize your employee by way other than cash remuneration, then you can incentivize them by giving them equity in the company. So now, in reality, what typically happens is the employees get options. So it's a right to obtain shares at some trigger point in the future, rather than getting shares directly. But in any case, yeah, you can either offer them options to obtain shares, or you can issue shares to them directly. For that, you would need a set of rules. If it's an option plan, it'll be the ESOP, Employee Share Option Plan rules. If you're going to give them shares, it'll be the Employee Share Scheme rules, plus a template letter of offer. Something else to consider is whether the options or shares vest, so whether they can dispose of them and get market value for them at any time. When options, if it's an option, can be exercised, the price they have to pay in order to convert to shares, what happens to those option rights or shares when the employee leaves? Does the company buy them back? And if it buys them back, then at what price, and so on. The employees may also be able to get some startup tax concessions as well if the company and the share scheme or option plan complies with the startup tax concession rules. It's probably a bit beyond our scope to discuss those rules, but you can check that web link to find out whether the plan or share scheme that you're thinking about would comply. It's more for the benefit of the employee than the employer. But again, this is an incentive for the employee. So if your share option plan or scheme rules comply, then it's a good thing. So we are just about out of time. So I'll hand you back to Connor, and then we'll proceed to Q&A afterwards.
Thank you, Sam. If anyone does have any questions now in relation to this webinar, or perhaps an unrelated question, but it's still related to your business, please just ask in the Q&A chat box, sort of in the middle to the right, and we'll cover it shortly. I hope everyone's found the content useful. For those of you who will be actually registering a business for the first time, it is worth noting we do provide a free registration call to go through our form for the ASIC registration. And you can read this directly on the ASIC website, and we see it all the time when it comes to actually registering a business. People add in the wrong information, or they omit information, or they don't actually create the legally required compliance documents for their new company, which is a breach of the Corporations Act 2001. So if you've not spoken to anyone about registration, what's the right structure for your business, definitely speak to, at a minimum, a commercial lawyer, if not also an accountant, to see what's right for you and what you actually need to tick off. We do have larger clients, but we are predominantly tailor-made for startups, and we try to help you from your day zero. So you're not too small for us, and in fact, in the eyes of, I guess, the lawyers, the size of your business is completely irrelevant. So if you are starting out and looking to scale your business, do yourself a favor and arm yourself with someone who can help you do that. I want to provide you with a quick overview of how LawPath can help in a broader sense. And as I mentioned at the start, we do have a 7-day free trial of our legal advice plan service. So if anyone is actually interested in that, I'll get you now actually to write or type yes into the general chat box, and someone can reach out to you to get you set up on that with your first call. But in a nutshell, yes, when scaling your business, there are obviously several tax and legal benefits associated with registering it in a particular way. And the choice of the business structure can obviously significantly impact your tax obligations, liability, and ability to attract investment. So in terms of the 7-day free trial, to put in perspective, within the traditional legal system, senior lawyers typically bill $600 to $700 for an hour's consultation, and that's just for their time, not including any additional costs, potentially contract drafting or the nature of the inquiry. What we offer is basically our entire document suite of 500 documents, and unlimited consultations and unlimited contract reviews for just $139 per month. But don't hear it just from me. Test it for yourself. We'll give you the whole week for free. You'll see that link in the webinar chat, and you can also see the link to our client testimonials actually on that subscription, as well as the link to the Meet the Lawyers page. You'll see some of our lawyers, very senior. They've been operating, some of them since the 90s. So for those on the webinar, it starts today, and you'll have full reign of the platform. But in terms of what that actually equips you with, as I said, you'll have access to our 500 legal documents. These have been drafted by our lawyers. They're up to date with Australian legislation. These consist of a multitude of company-related documents, documents for your websites, employment contracts, HR-related contracts, and different service level agreements. They're 99% complete, so you literally just have to fill in the relevant information for you and your business, and the contract management system and the software will direct you through each provision clause that's important. So it's literally impossible to put a foot out of place, and only takes 5 to 15 minutes to complete the documents. They are also fully customizable, so you can delete and remove clauses. However, if you do remove something that obviously jeopardizes the legality of the document, it will flag and notify you. So if you are actually adding in your own provisions, it would be well advised to speak to one of our lawyers. We do offer unlimited on-call contract reviews, so you can check it first. Is what I'm actually adding legally enforceable? Is it compliant? And would you recommend me adding anything else to basically tailor it to my business? Obviously, these consultations as well, generally speaking, are unlimited. So if you do have more questions on this webinar or anything else pertaining to your business, you can book in to speak to someone to get those answers. There's 100 questions you could ask, but a great starting point is obviously you need to understand what's the right business structure for you. You need to know what contracts, documents, and agreements you may need to establish for your clients, for your partners, potentially for any suppliers, and always, emphasizing that those protect your business and your interests. You can also ask us around intellectual property, including trademarking. And I see a few people from the poll are looking to hire employees or have employees. So if you are about to hire, and you want to know some of your obligations and responsibilities as an employer, you can get that information from our legal team. There's obviously some great AI features as well there to assist you, especially outside of business hours. There is an Ask Me feature, there's a draft, a review, and simplify mode, as well as translate to assist you when you're looking at the documents. Practically, as always, everyone on the poll listed they have questions around GST tax deductions, and tax compliance, and we do cover this as well. So you may actually, in the long term, want to look at our most comprehensive package, which is our legal and accounting advice, and there you can actually get unlimited consultations of our award-winning chartered accountants. And you may have an accountant already, but if we are more convenient and potentially more cost effective for you, and perhaps you're considering having both legal and accounting under one roof, you may want to have a look at utilizing that additional subscription. And from there, you can actually discuss tax minimization, tax concessions, and deductibles. And our accountants do cover business structuring advice as well as advice on not only just GST, but capital gains tax, crypto tax, and PAYG as well. But to get the full package, there's also the tax compliance, so they can actually do your BAS lodgements, tax lodgements, and financial statements. And while, as I mentioned, you do get unlimited consultations with the accountants, you do get a special fiscal year consultation to do a deeper dive analysis of your business spending and revenue. So just to wrap it up, for all our attendees with that 7-day free trial, you'll have immediate access to our templates. We can get you booked in for your discovery call as soon as tomorrow. It's basically an opportunity to outline your business with any short and long-term goals, discuss any pressing legal issues that you're faced with, and most importantly, explore any legal gaps in your business that you may not be aware of, as you don't know what you don't know.